Thank you for the opportunity to address the committee on this very important legislation. We're from the Children's Rights Alliance, which is a coalition of 104 organisations, and we were founded 17 years ago with the primary objective of promoting the UN Convention on the Rights of the Child, which is the most universally accepted international human rights instrument. First of all, we were going to just make 2 points to the committee, but we do want to acknowledge the work of the working group on the merge of the equality and human rights bodies. It's an excellent report, some excellent content there, and also the Minister for Justice for producing this draft legislation, which is broadly very welcome. Our focus here today is on the 1.2 million children in this country, and particularly those that are most vulnerable. And the most vulnerable ones are those that belong to the different groups that are discriminated against every day. The Equal Status Act protects them and prohibits discrimination in relation to goods, services and education, and is actually a very important tool to protect children and their families. In 2010, 16% of cases under the Equal Status Act were taken by children in relation to primary school education and secondary school education. So we just wanted the committee to be aware how important this body potentially is for children, particularly in relation to supporting children and their families to take cases under this particular Act. The Equality Authority did some excellent work, particularly before the cuts, because the cuts did hamper their ability to support individual cases. But remember, these are the most vulnerable children in the country. A lot of these cases involve children with disabilities, traveller children. There's been some cases on the basis of religion as well. And when the Equality Authority was involved in the case, the person was more likely to continue with the complaint. But also, the Equality Authority was very important in developing the jurisprudence under the Equal Status Act. You can see very different decisions coming from the Equality Tribunal, which is the adjudication body, when the Equality Authority was involved in those cases. So it's very important that this practice and experience is taken forward in this new body as well. Because remember, if individuals don't take cases, the legislation will not be enforced and it won't be developed over time. The legislation at the moment, the draft heads of bill, is broad enough to allow the Commission, the new Commission, to support such cases. But what we're worried about is resourcing. If they don't have enough resources, it's unlikely that they're going to be able to support a broad number of cases. And we'd urge you to take this on board and review it in the legislation to look for a solution to ensure that this is a very strong area and function of the new Commission. Moving forward then, I suppose, remember, a lot of children won't take cases and a lot of families won't take cases. And certainly one of our member groups recently spoke to us, Belong To, which works with children and young people who suffer from homophobic bullying in particular, say a lot of children won't take cases. It's too difficult to do it. It could be a year, 2 years to take such a case, and it would single them out. And I'm reminded there of the case of Sarika Singh, which is, Senator Batchik will know it well. It's a major UK case, really important case because it demonstrates how a judge can deal with a positive duty to promote discrimination. Sarika Singh was a Sikh young girl. One of the obligations of the Sikh religion is to wear the kara, which is a bracelet, and her school lost their case because they failed to promote the equality duty within the school. But speaking to one of the lawyers in the case only a year ago, she told me that one of the problems for Sarika was that she took the case, she won the case, it was really high profile, but she was effectively bullied out of the school by the other children. So I suppose for me it was a real reminder of the importance of having a positive duty on educational establishment and other service providers to promote equality, and that's something that is in the draft heads of bill, and my colleague Edel Quinn will talk about that in more detail.
Thank you, Tanya, and good morning to the committee members. As Tanya said, I'm going to speak very briefly about the human rights and equality duty on public bodies under Head 36 of the bill. And this is a very welcome inclusion in the bill, as is its broad scope. Proactive measures, as Tanya said, such as this duty are essential addition to the human rights infrastructure of the state and are especially important for vulnerable groups such as children and their parents who may not wish to or may not be in a position to take a case before the courts. Effective human rights and equality proofing of legislation, policy, budgets and decisions from a child perspective has a direct effect on children and their families and plays a key role in strengthening the protection and vindication of the rights of the child. The Alliance believes that the human rights and equality duty of public bodies under Head 36 could be strengthened and the impact for children and their families more powerful if the duty were to go beyond the due regard standard. Clarity is required here because under the heads of the bill, the due regard standard is explained as being as a consideration that has to be given to the need to eliminate prohibited discrimination, etc. But then under, and this may be a drafting issue, but under the explanatory notes, it goes beyond a consideration and it goes into positive actions that are to be taken to address issues that have arisen and to preempt future problems that may arise. So there's a discrepancy there, and we would support the wider definition that it would include action to be taken, not just a consideration to be given, but if that is the intention, then that would need to be included in the heads. And then my final point relates to compliance. We believe that the Commission would be in an ideal position to monitor the compliance of the public duty, because essentially this is a role in it's an exercise in self-regulation, and there is a danger that that could become a box-ticking exercise. Now, we support the recommendation of the working group in their report that this would that this is kind of perhaps a future role that the Commission would take on, that there would be a review in 3 to 5 years to review the effectiveness of the duty, but that if that is to be the case, then that if there is a review to be undertaken, then that should also be included under the in the actual legislation. Those are the points that we wanted to make, and thank you again for the opportunity to make.